Alex here with part 77 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This is a video that I do have quite a good recollection as to my mindset at the time. I had thought that by substituting out one of my friends for another, and we're talking about two attorneys, I substituted Clifton Young out for Monica Caffaratti. My goal was, number one, to not overburden Mr. Young, because he was just there for that one hearing on the school dispute that I brought to the court's attention, and also to bring on Ms. Caffaratti, because I assumed that by having an attorney of record on my ex would be easier to deal with. I thought maybe she wouldn't try to take advantage of so many things, I guess you could say, gray areas, loopholes, etc., etc. I thought that having an attorney would make things stay peaceful. And it was probably because when I had Mr. Young on, things were more peaceful. Maybe there wasn't as much conflict. Maybe my ex wasn't responding in the same argumentative way that she was. I'm not quite sure, but I assume that I preferred to go from Mr. Young to Ms. Caffaratti rather than from Mr. Young back to improper for some kind of reason. What I do recall is that my ex got worse. She didn't get better, she got worse. I also noticed, and so did my attorney, we noticed some really weird things. For example, there were a few situations where my attorney had to put together a proposed order, had to confer with my ex, and she wouldn't confer over the phone or an email. She insisted on meeting in person with my attorney, and my attorney was weirded out by it. She was like, I'm not going to meet you in person for something like this. This is not something that requires meeting in person. And my ex kept insisting, and there was actually an email that my ex sent me at some point in the process where she said, now you get to see what it feels like to spend money on an attorney. And so when I started to get all of those vibes, rather than think, oh no, I need your help, I thought to myself, you're my friend, I'm not paying you any money. Yeah, I could use your help, but I'm not going to burden you with something that I can continue to do, something that I've been doing on my own for years. So I reached out to my attorney and I said, you should just withdraw from the case. I'm going to have to start filing a few things. And I felt bad. I didn't use my family's money because I felt bad. And I didn't use my friend for her legal skills because I felt bad. And it just didn't feel right for me to do that, to burden them. Anyone. I didn't want to burden anyone with my case. So I asked her to withdraw, and she prepared a motion, and she got some signature from me that we filed with the court so that she could withdraw. And that's pretty much what this video is about. It's a motion to withdraw as counsel of record. And she does eventually come back to help me several years into the future. I think it's around 2014. So this attorney does sign back onto the case, helps me out a little bit more, and then she ends up having to withdraw again because my ex just gets worse when I have an attorney. It was very backwards as to what I had thought. I had thought having an attorney would make her less likely to try and do things that would trigger litigation, but it was actually the opposite. She got worse. Anyway, with that all being said, we can go ahead and take a look at what my attorney has filed. Here we have the motion to withdraw as attorney of record. And as you can see, it's been filed by my attorney, who identifies herself as withdrawing counsel. She submits the motion to withdraw pursuant to Supreme Court Rule 46 and Local Rule 23. This is relevant because there are different ways for an attorney to be removed from a case. And I think I actually did mention this. In fact, for sure I did mention this when my two attorneys swapped out. They didn't have to use this rule. They used a different rule which allowed them to file a substitution of counsel and did not require the court's supervision or approval. This is a motion to withdraw completely. And this is a motion that does require the court's approval because she is not substituting herself out for another attorney. She's substituting herself out so that I can proceed in proper person so that I can represent myself. So the different local rule applies, and that's WDCR 23. And that's a local rule that requires the filing of a motion and requires the approval of the court. Next page here is a list of exhibits. And Exhibit 1, going into the declaration that I prepared. And it simply states that I, Alexander Falcone, am the plaintiff in this case. I relieve my attorney of any further legal representation in the above numbered case, and all further notification can be mailed to me at my address. Here we have the certificate of service filed by my attorney, indicating that she is depositing this motion, the previous one that we went over, into the mail so that my ex can have it mailed to her. And this constitutes, well, actually, she sent it to my ex's attorney, which is, of course, what you're supposed to do. So she sends my ex's attorney that motion that we previously went over, and this is a certificate of service proving to the court that it was indeed sent to my ex's attorney. Here we have the request for submission. I wonder if she gave my ex's attorney time to oppose. No, she did not. She apparently she submitted it to the court immediately. So my ex's attorney didn't have an opportunity to oppose the motion, and I assume that I didn't need an opportunity to oppose the motion because I filed that declaration, which is attached as Exhibit 1. So I think in other situations, an attorney might wait the number of days necessary to file the request for submission. And you can learn about what I'm talking about by watching my video Computation of Time. But in this particular situation, my attorney just filed a request for submission immediately, thus submitting the motion to the court for approval immediately. Here we have a list of exhibits, and here we have Exhibit 2, which is supposed to be Exhibit 1. There's no Exhibit 1 in this motion. She probably just accidentally did that. But here we have Exhibit 2, which is an order. It's a proposed order. It's submitted to the court that allows my attorney to be relieved from the case. And I'm sure that well, actually, I'm not sure. We'll have to take a look and see if the court actually used this proposed order or if the court prepared its own order instead of using my attorney's proposed order. Just a blank, unsigned order. If you want to learn more about proposed orders, please watch my video, Proposed Orders. I don't like to talk about it too much because it's a very complex topic, and I already have done a video on the topic that's dedicated to the topic. Moving on, and we have the judge's order. So he did not use the attorney's proposed order. He basically had his own order drafted, and it's a very brief order. In the first paragraph, he indicates that he reviewed my attorney's motion requesting to withdraw, and that it was submitted for a decision on the same day, and that pursuant to the Supreme Court rules, the motion to withdraw and be relieved as counsel by my attorney is granted. All further communication in the matter can be served on me personally. Certificate of mailing indicating that he has mailed this order, allowing my attorney to withdraw to myself, my attorney, and my ex's attorney. Going into the aftermath, my attorney filed one motion, a certificate, and a request for submission. Those were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. My attorney prepared a motion, a certificate, and request for submission, but she did so for free, so I incurred $0 in attorney fees. The order allowing her to withdraw would have been reviewed by her for free. Again, $0 in attorney fees. My ex's attorney would have probably spent no time at all reviewing any of these documents. I suspect she would have spent not even a phone call. She probably just sent my ex an email saying Alex's attorney withdrew. That's it. I'm going to lump all of these filings and the order into a total of 15 minutes of review time for my ex's attorney, and possibly to update her computer system, etc., etc. And that is going to, at the rate of $250 an hour, come to $62.50 in attorney fees. As with my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.